Hello, everyone. Thank you for joining us here today. We have an interesting conversation today with two very good friends of mine. The idea here is just to have some interesting conversations with people in the industry, and what prompted this particular conversation is Scott McKeown, who many of you know as one of the preeminent PTAB lawyers in America. I think he's still done more PTAB cases than anyone else. He has decided to move past where he was in his last affiliation, and now he is going to head up the DC offices of Wolf Greenfield. So we thought that this would be a good opportunity to talk to him, see what he's thinking, maybe tell us a little bit about why he's making the move. And also joining me is John White. John and I, we have been traveling the country now for 25 years. It's hard to believe it's that long, talking about patents, and we've talked about doing this kind of a show. I don't know which one of us is Johnny Carson and which one of us is Ed McMahon. The weight would suggest I'm Ed McMahon, but we'll see how it goes. So thank you all for being here. Really appreciate it. And let's, Scott, get right to the critical issue. What is with the mullet?
Well, see, that was the issue. You know, Ropes and Gray has a no hockey hair policy, so you know, I had to move on. But
are you going to be announcing that you're going to fight for Dana White in the UFC?
No. It's my son sort of started talking to me about mullets as if he invented them, and I told him I had done that back in the '80s, and so I felt like I had to outdo him. So we'll see how long it lasts. It's getting a little ratty looking.
So you did not dissuade him from? Because he can't possibly be like Dad.
No,
right?
Of course not. I mean, you know, he would have to have. Well, I won't get into the tail and the bleach blonde that I used to have, or the earrings or anything. But
so I would think that in order to do this, he probably saw you growing a mullet and then thought like maybe the exact opposite. Maybe I should just shave my head.
Well, they grow them sort of forward now. It's a sort of a monkey's Mickey Dolenz look, but you know, it looks good on him, I guess. At least I have to tell him that.
Yeah. Well, good. Well, thanks for being here. John, any comments about Scott's mullet before we get serious?
I'm working on my own, but it doesn't seem to be coming in very fast.
Yeah. You're letting it grow right in the middle and the top. And I can't talk about it too much anymore, which is why the cameras are pointing
anymore.
Up a little bit. But I'm glad to have you here. This will be a fun conversation. So in all seriousness, let's begin with really just why did you decide to make the move? Was it an opportunity at Wolf that you just couldn't pass up? What's going on?
Yeah, so, you know, leaving Ropes and Gray, obviously very difficult. I worked with some amazing lawyers there and was able to partner with, you know, one of the best appellate practitioners in particular in the country. So nothing but just stellar experience there and just fantastic attorneys that I work with. But that's what it was. I mean, to me, it was more of a chance kind of to go home a little bit, spending prior to joining Ropes 17 years at a boutique and you know, what I consider to be one of the better, if not the best boutiques in the country, opening up an office in Boston, you know, after New York and growing out of, not Boston, D.C., growing out of Boston to New York and now into D.C., you know, having that in my backyard, I think, was just, you know, an opportunity that just really resonated with me, you know, being able to go back to sort of that, you know, entrepreneurial environment, you know, hopefully less conflicts. And so, you know, there were some, you know, definite advantages there. And, you know, a little bit working with some of the folks at Wolf over the years, co-counseling and just seeing the quality of the work there and a little bit of what's been going on in the industry. I think, you know, for a firm like that, there's just nothing but opportunity ahead.
Yeah, John, we hear that about conflicts a lot. You know, you hear from the patent office people who are all excited they're leaving the patent office and then they're going to go to a firm. You talk to them 6 months later and they say they love it. They just wish they could take a client.
Right, and you know, Scott and I were talking before we got started about the changing landscape of firms and combinations in our field over the past couple of decades. Mm-hmm. You know, you've seen long-time name brands swallowed by general practice firms, and sometimes this works and works well, and sometimes the transition is a little more difficult, and conflicts is sort of the headline issue and has been probably for about the past 5 to 10 years. People find that they're conflicted out of a lot of stuff, and it was hard to anticipate. And then the patent office kind of spelled it out for us.
Right.
You know, what we should have been doing, I guess.
All along.
Yeah, it becomes difficult. That's a difficult sieve to get through.
Yeah, yeah. And you just not too long ago joined Harness yourself.
I did, and interestingly, I left my clients behind at my old firm. I had sold my firm once, and it stayed sold, and then I personally moved on to Harness and am now engaged deeply in business development for them, which is great fun. You know, I get to evangelize essentially about patents all day long. Even if I disagree with Scott, I get to evangelize.
I evangelize
sort of
on the other side.
That's sort of a given. We always disagree with Scott, and I tell
yeah, but he's always right.
That's the thing. I tell you, you frustrate me so much. I almost don't want to ask you anything about where the PTAB system is going.
Because he's going to know.
Because I'll lose sleep tonight, and knowing that you're going to be right. But before we go into, like the subsidy, and maybe this gets us sort of going in that direction a little bit, but you're still going to be staying PTAB focused, right?
Yeah, I'll still be focusing on the PTAB. If anything, what this does is a little bit gives me an opportunity to work more for patent owners. I do get a fair amount of startups and other companies that would come to me and say, well, can you build these portfolios out? You know how to take them apart, so help us build them. And not having a prosecution capability, made that difficult. So, part of the justification for the move is, believe it or not, I know everybody views me as the anti-patent hater, but it gives me an opportunity to work a little bit more on the patent owner side and craft some portfolios.
Well, Darth Vader turned out to be good too, right?
In the end. Remember, Scott, Darth was
but he
good.
was dying at that point.
Well, yeah, okay, all right. We're not dying.
He lost a few limbs, but he was good.
But let's go down that path where you were saying, consulting. It sounds like with existing clients or bringing clients in for this purpose, and you can take them apart. So how do we work this so that they can't be taken apart? I sort of had an epiphany this morning, and I was just sitting there and looking at potential panels and topics for our event live in September, and it just dawned on me that I'm getting sick and tired of hearing from patent owners who complain about the litigation system is rigged, the PTAB system is rigged, they're taking our patents away. Okay, look, I'm sympathetic to that, but patents have become a commodity. And if you are going to treat patents like a commodity, you ought not to be shocked when the PTAB finds them invalid. When the district court says, well, maybe it's infringed, but this is not the $100 million patent or $1 billion case you think it is. Mm-hmm. And you hear about just the dumbest decisions being made during prosecution, and it's all to save a buck, cut a buck, and then at the other end, they won't ever cut anything loose. It's like, okay, you're on the 6th RCE. I think the examiner has told you no, and if this is still relevant for you, then you got to appeal. I mean. Yeah. You shocked? First, let me ask you: are you shocked to hear me talk like that, or is it about time?
No, because I prosecuted for years, and it always reminded me of like life insurance or car insurance. Nobody wants to pay for it, and then when you really need it, you're thinking, oh, I really wish I didn't agree to that high deductible, or I should have paid for more coverage, and it has become commoditized to a certain extent. You have companies, well, I only have X amount of money in my budget, but I want to get 100, and it's all about numbers instead of quality. I think a fair number of companies have gotten away from that, but when you look at a lot of folks that have had bad experiences at the PTAB, and I look at their prosecution or their claims, and I sort of think as a prosecutor, well, I'm not really surprised that didn't work out in your favor. So it's unfortunate, but you get what you pay for. Unfortunately.
Yeah, you do, and it really is becoming. It's difficult to listen to some of this stuff, and I understand choices need to be made, and you can't always do what you want to do, and that sort of thing. But I probably shouldn't name names, but there's been some portfolios, I guess you would call them, smaller portfolios I've seen, where I think that the inventors ought to just be thankful they got anything, and then the fact that they're making money licensing, or in at least one case, they made money litigating. And in that case, it was really against somebody who was just a rip-off artist. So there's always that helps the patent owner. But, you know, they ought to be thanking their lucky stars based on some of the poor prosecuting that is out there.
Well, and some of it
I don't
is...
want, let me say, not poor prosecuting from the attorney standpoint. Yeah, we all know how that happens, right? Attorney, if somebody comes and says, look, I only have $5,000 for a $10,000 job, well, you're not going to do a good job.
Right. If you're just taking the narrowest claims or the allowable subject matter, you're probably not doing yourself, a favor. But to me, it's also a lot. Attorneys never want to change, especially when they think they've found sort of this winning recipe. And I remember, like I said, 15 years ago when I was doing prosecution, and I'd have a litigator come to me and say, well, get this claim, and that's all I need, right? That'll give me infringement. I'll be happy. And I would look at them and say, well, it's not valid, but I'll try. It reads on the background, but okay. And you could do that when the district court was the first hurdle, because you can't make up well, I shouldn't say make up, but you can't hide behind burdens and things. You can't change the facts. You either infringe or you don't. Whereas validity, I think it's a little more squishy. If you got a really good attorney, I've seen some technical arguments that I just sort of say, well, it worked, but
right.
And with the PTAB being the first real hurdle now, you kind of need a little more in your claims, and that's not to say just claim them narrowly, but meaningful dependent claims, and you're prosecuting really for that PTAB being the first hurdle, instead of, well, just get me the broadest claims possible. And there's just a lot of attorneys just that never have broken out of that mindset. Right.
And it reminds me of a conversation many years I had ago with Gary Mickelson, who was the billionaire back surgeon who he's probably got by now 800, 900,000 patents worldwide. And, people they say, oh, well, they're not all that unique. They're not that interesting. He turned back surgery from laying in the hospital for weeks to a couple days to eventually a lot of it's outpatient. I just had my hip replaced, and now these things are outpatient. These innovations matter. And the fact that somebody would have gotten there in 20, 30 years, that's just ridiculous. The whole system is set up. We want him to get there now. But he always told me, I want the broadest valid claim I can get. And one day he asked me, he said, why would I want an invalid claim? He said, it's just going to cost me more money than it's going to do any good. But John, there's this idea still in a lot of firms where, there's backslap high fives over the ridiculous claims that you sometimes see.
Well, I've sat on panels with in-house folks, and their primary concern is budget and being responsive to those that they answer to within the company. And the general counsel seems to care only about what they're spending, not what they're creating. And I think this is poor communication on the part of the patent attorneys. Maybe we can't speak the speak that is spoken at the C level or something like that. We don't seem to get the message across that without good patents that can survive a round or two of PTAB stuff, you don't have a seat at the table down the road. You're not part of 6G, 7G, whatever it's going to be. And if that doesn't matter to your management, then I guess it doesn't matter to you either. But it does matter to them. They're just not aware that, aren't we spending enough? No.
No, you're not.
You're not.
But it's a cultural thing, right? I mean, your CFO either gets it or they don't get it. If your CFO, if you're at a place where, as an engineer scientist, where the CFO sees patent as a cost center, you need to move on. I mean, because that's going to be a failure. Because if you do wind up inventing the next billion-dollar invention, it's going to be worthless.
But Gene, you and I know we've plumbed the depths of some of these portfolios. This was probably 10 years ago. We went and took a real close look at a few of a company that's really not there anymore, Motorola, for example, and discovered that there was no there there. They had a lot of patents that you wouldn't want to paper a room with. They were awful. And they'd spent name brand money with name brand firms, and we were shocked.
I was shocked. There was, because we were looking at trying to find, it was a tool I created that we still use today for working with inventors.
We were just looking for good examples.
How they could draft their own patent application. So what I wanted to do was use Motorola examples, because we were pitching this to, you need to use this Motorola. It was very difficult to find patents that they had filed where it had and all I had in the system at the time was like 10 questions that had answers to each of those 10 basic questions. Because my philosophy was, is if somebody who cares could see it on paper and see it start to develop, now they know how to expand it and make more sense. But there was an awful lot of patents in that portfolio where they were, you've been here with us for 10 years. Here's a plaque with a patent on it with your name on it. Are you at the PTAB? Do people fight over that stuff? Do you see that stuff? Is it what is the, like, if you had to tell somebody, like, the number one thing to be on the lookout for during prosecution is?
I think it's trying to get the Holy Grail claim instead of building out a portfolio of, well, I'm not going to get one claim that covers the entire industry, but I can target that competitor with this application, this competitor, have some variation in my claim scope, stop filing dependent claims that are just useless, wherein the transmitter is a radio for, you're not getting anything with those kinds of claims. And there are some companies that approach it as a numbers game. Well, yeah, my patents may not be that strong, but I've got 60 of them, and you're going to have to kill all of them. That's one strategy, but
but the thing is the way the economics are today, it's worthwhile to kill 60 of them if they have to. I mean, because now I don't know that this federal circuit is ever going to get there, but there will be in our lifetime, maybe within the next few years, billion-dollar verdicts that have to be upheld for damages of $1 billion or more dollars, simply because of the number of people using the number of gadgets and the math. I mean, the math is the math. If it's a $5 billion case because everybody in the civilized world has one in their pocket, and you owe me a penny or two for every one, or 50 cents for every one, that you are selling for $1,000 or $1,200. The math is the math.
Yeah. And well, that's a lot of the standards, right? I mean, there's mountains of patents that allegedly read on them. Some of them aren't the strongest in the world, but there's a ton of them, and you're not going to kill all of them. See, now, and that's
this is a thing that comes up. I mean, you've been at the SEP event in the past that always comes up, and I hear Judge Essex, Ted Essex, in my ear saying, well, they're all standard essential. And I get it, because, you had to disclose them without knowing whether it was ever going to be in the standard. But I also get the other folks that are saying, look, I'll pay you for the ones I'm using.
Yeah.
But I don't use 30,000 of your patents. I use like maybe a couple hundred. And what's the solution? John, do you have, what's the answer to this? What's the way out for us?
Well, following up on something Scott said, and that is, he will now have a chance to help portfolios that can be defended at the PTAB. And I think that's the way out, is we've got to get away from just numbers, and we have to get to quality. That's our way out, is quality.
Right.
Because if we continue to focus on numbers, all we'll do is we'll create more of them. And you can see that around the world. China has some unfathomable number of patents being passed out the door. Are they better off because of those numbers?
So, but I understand what China's doing with that. I mean, if you had, like, let's just say hypothetically had no patent system in the 80s, which is pretty close to true for them. And no.
Well, no, it started in 85.
Right.
So you're exactly right.
Yeah. No patent system, zero. And then you've gone with a bunch of leaders who were maybe older and didn't understand the importance of technology. And now China has a leader that really, he himself has been around the world, educated around the world, seems to understand technology better than many leaders, and wants to have his own people inventing. What would you do? You got to encourage them that, hey, this thing called a patent exists, and you might want to aspire to get one. And and they've given every kind of incentive. The one that Judge Rader always talks about that I laugh at is if you were, I don't know, this still is for a while, if you were in jail in China and you filed a patent application, you got your sentence reduced.
You could get sprung.
But you got to have, I don't know that I would have.
That's highly motivated.
I don't know that I would have used that particular motivation tool, but you got to incentivize people to do it.
Well, and they've done a 180. I mean, I think China looked around and said, well, we're paying everybody for all these standards, and we're not doing that anymore.
Right.
And have made it a government priority, and you see what Huawei and others are.
Yeah, they just made an announcement of $1 billion of revenue off licensing.
It's hilarious. People think China is a communist country. China is, in a lot of ways, more capitalist than we are. I mean, it is, I guess, maybe a socialist capitalism. It blends these things together in a way that I wouldn't prefer myself. But
it's that iron fist that can just change. Here in the U.S., it takes us. We're still, we're 10 years into the PTAB, and everybody still wants to unravel it. So we don't adapt.
Okay, not everybody. I know that.
I want it repurposed.
That comment was thrown in my libel. I don't want the PTAB gone because the PTAB has to exist, right? I mean, what's the alternative?
Yes.
I mean, first off, you're going to have the people, everybody people hate me on both sides of this PTAB issue because the inventors say they want to get rid of it, and I'm like, wait, that's unrealistic. It's not. What are you going to do with ex parte appeals? Where are they going to go? Mm-hmm. Okay. And we'll keep that part of it. Okay, so the PTAB isn't that bad. It has to exist. And then what about these patents that really suck? The patents that are bad for whatever reason, whether it's you wanted a patent on a wheel, the examiner said, look, I got a pile of work here. You want a patent on a wheel, go for it. You want to pay maintenance fees on a wheel, I'm happy to give you those kinds. And then there's got to be a solution for that. And then also the late arriving stuff that people missed.
Yeah. Well, what I hear a lot, especially when it comes to the PTAB, is, just in patent reform in general, is, we used to have the gold standard, and we need to go back to the gold standard. Well, when we had the gold standard, we had injunctions, right? It was mostly competitor suits, right? People weren't going to Texas. We didn't have the vast majority of litigation in Texas. So we've had all these bad actors, frankly, not all of them, but, certainly a decent amount, come in, and we want to say, well, let's go back to the gold standard without doing anything. We're these people that have screwed it up for everyone. This is why we can't have nice things. Yeah, we used to have nice things.
That's funny.
But the system changed because it adapted to what people were doing to it. So we can't go back to that gold standard without doing something to the people that have been ruining it for everybody else.
Well, and that's the thing. I've said for the longest time, I feel like we get treated like we're a bunch of third graders. One person speaks while you're all in line for the bathroom, and then everybody loses recess.
Right. It's like boot camp. Yeah.
Right. That's what our system has to be able to strive for better than that, and that's what's annoying. I mean, because there are things that could be done, and I don't know.
I think PTAB reform. I think the PTAB continues to exist, but it needs to be sort of reeled in. I think the role it's playing, the outsized role it's playing, was not anything envisioned by those who created it. They thought it would help the district court be more efficient, faster, cost savings, and now it's turned into more of a bludgeon, a cudgel, and given the expense of it, there are those who just aren't ready for it, the speed of it, and all that sort of stuff. So it's really the due process aspect. I mean, but I'd like to see it reformed. I think it has an important role to play. I don't think there's ill intent. I think initially the PTAB, there's probably some political wind, when it was first created in certain areas, and those who were hired felt they had to act accordingly in some ways. But I think that's gone by now. Yeah. And I think it's just we're doing the job that is in front of us according to the law that is there.
I guess. I suppose that's right. I mean, there's a lot of me that somehow disagree. Like if a third of patents go down as being invalid in district court, why are 2/3 of them going down as invalid at the PTAB? I mean, that to me suggests that there's some kind of incongruity here that needs to be addressed, and I think the right answer is closer to the third than closer to the 2/3. There's also, and I have written at times that the PTAB may be so broken that it just needs to be thrown away and we start over.
You've said that about the CAFC.
Well, but there's reasons for this, right?
About the Supreme Court.
Well, I haven't said about the Supreme Court simply because it's unrealistic to get rid of the Supreme Court. But they should stay in their own lane, get out of patents, right? But because they don't understand. For a bunch of people who years ago, Justice Kagan said they don't use email. Well, if you don't use email, why are you deciding patent cases?
No, Judge Rehnquist, I thought, had the right approach. The CAFC knows what they're doing. We should stay out of it.
Unless there's an extraordinary issue, of constitutional importance,
right.
or they clearly got something. But the thing that frustrates me, and this answer is we have to go with one litmus test or the other. Well, then I'll pick one, the one that works for me, because if we're going to operate on the polls, the other poll to me is just so horrific that we have to do it my way. And I feel that same way sort of with the PTAB at times. If you were really going to say, PTAB, that an MRI machine is abstract, okay, well, and we can't, and then the problem is when it goes up to the Federal Circuit for review, they get the agency deference, substantial evidence in there, and it's like, oh, well, the MRI machine, it might not exist. They might be abstract. It's not abstract.
Well, but that gets into the ridiculousness of the 101 case law to begin with, which, to your point, the Supreme Court needs to stay out of it, but Congress needs to come in and clean it up. And if, for Congress to do that, and they've tried a lot, the stakeholders need to stop being on these two poles that you're talking about.
Right, no, absolutely.
It's got to be my way. No, it has to be my way. Well, then we'll leave it the way it is. And,
right,
and everybody's unhappy.
And everybody's unhappy. But the problem, too, with the PTAB, like, there's just so many. You learn in law school, statute of limitations are fundamental. But now it's like you can't bring this case because the statute of limitations expired for you, but somebody else brought a case, so we'll just let you join their case. I mean, I missed that day of Civ Pro. I mean, and I've asked every judge I know, can you think of any area of law where that is the view of statute of limitations? And I think I could say that the answer is no, that doesn't exist anywhere but at the PTAB. But what I will say is nobody has yet given me an example of where that fits with our notions of what statute of limitations is supposed to be.
And well, that particular provision, the joinder provision, there wasn't, I'm not aware of any legislative history on where that even came from. I mean, ultimately the idea, I think, was, well, we have this public policy interest in getting rid of bad patents, and if Party A comes in and challenges it, and there's other people out there with an interest, right, let's bring them all to the table. May not be fair from sort of a statute of limitations perspective, but I think there you're weighing more the public policy of, well, do we want an invalid patent being asserted against folks when, maybe there's someone else out there that could bring better evidence to the table.
So, and this gets us to if we could lock ourselves in a room and fix this system and make a better system, I think we all could, because whenever I raise that issue about quieting title and that sort of thing, Judge Tierney always just says blonder tongue. And I'm like, I have the same feelings about him as I do about you. It's like, he's right, and I hate that that's right, but that's what the law says right now. So we have to change it, and if I'd be totally okay with saying joinder's fine, but at the end of the day, if this is going to be a property right, it has to settle. There needs to be a limit. We do it on the trademark side, where trademarks can last forever, and if you have one for 5 years, it becomes almost impossible for others to take it away.
But I guess the issue there is with trademarks, right? The trademark issues, what class it's in, and anyone that has any interest in it can come and contest it or do whatever they have to do. Where someone gets a patent claim, some random patent, and you're some small company, big company, whatever, you can't possibly police, right? There's no classification that says, hey, pay attention because you could get sued on this 10 years from now. So there's not that clean system.
I mean, I understand the argument, and the argument is logical. The reason I don't buy that anymore is, like back in the days when the gold standard days, like you were just talking about, patents could be enforced against a lot of folks who, you mean that patent applies to me? Well, it talks about data. It doesn't talk about money. You're moving data. And it's like, well, clearly they're talking about payments. No, it says data. So I get that. But do you think today those kinds of patents that are that kind of a different level of submarine, that you are going to be applied to things that nobody at the time thought that this could be applied to, have any chance in the system today?
They're still out there, and that's part of the problem is you pick up, I can't tell you how many times I would pick up a patent that's asserted against one of my clients, read the spec and say, oh yeah, it's pretty clever. Don't see how it has to do with anything we're doing. And then you get the infringement contentions and you just like, what? Those words don't mean that, right? I had a guy in New Jersey that was editing video in his back room and got this patent on changing formats and claimed that he had invented the DVD standard, right? It was just kind of silly. But you get into the district court where the focus is more on the language and the words and less on the technology, and you can get to some of those interpretations at least far enough where, right, somebody's going to pay you a settlement rather than risk going to trial. So they're still out there.
Well, see, that's the other thing too, and I'm glad you brought that up, because there are if a troll exists, and I think they do, there are these people that are filing these lawsuits, and their first demand is $100,000, $50,000. Now, I'm not talking about if the value of what has been added from the patent is rightfully $100,000. It's not what I'm talking about. I'm talking about these people that just randomly start out with $50,000 to $100,000 as their first demand, and you say, no, we're not going to pay this. Come hell or high water, we're never going to settle. And then they're like, okay, well, what about $35,000? Just that quick. And then, no. I was like, well, how about 15? Can we talk?
Would you believe 10?
And then you get down to 10 or something like that, and then it's like, who do we make the check out to? And some of those conversations are like 60 to 90 seconds long. Yeah. They are literally shakedowns, and it's all done, not all of it, a lot of it is done before the first conference, the scheduling conference, because you don't want the judge to know that you're using his courtroom or her courtroom as scene one for the shakedown. But those types of things were supposed to have gone away when we did the PTAB. And they don't. And obviously in these cases that the PTAB cost a lot of money.
Right. And that's the calculus. Well, I can pay 10 grand and it's definitely gone, or I could pay 200, fight it for another 18 months, and maybe it's not gone. Maybe a claim survives. And so, it becomes a very easy business decision. The problem is then you become an ATM and people just start lining up.
See, that's the business Unified should have gone into. Maybe they will go into it now, because those folks don't ever really go away. I mean, John, you remember we had these conversations with some people saying, well, we'll settle it, but you have, in the settlement is like that you don't know of any other patent that you own or a related entity owns that is being infringed by the defendant. And that language in a settlement is often a deal breaker with these kinds of situations. I mean, why is that?
Well, yeah, because they've got 36 shell companies, and you don't know that they're the other party that's going to sue you next week. Yeah. They know what they got out of you.
Right,
they
on
know,
a different patent, exactly.
They know how they got it, and you don't know it's the same party, but...
Right. So, but until that part of the industry gets resolved, and I think it's a mistake for inventors and pro-patent people to act like that part of the industry doesn't exist.
Well, but maybe that's a state AG kind of a thing. You go in with racketeering and stuff like that to stop it, because on the patent front, we're just not equipped and don't have, we can't move that fast, It's just the way it is. And so, extortive, widespread
those demand
claims.
letters having a schedule of, well, you can pay me this much next month, or, they've gone away, thanks to state AGs, but it's just turned into, well, I filed the complaint, let's have a conversation on the phone, right? So it's gone underground to an extent.
And but does need something to be done about that. And I've always thought, I think it could be handled better by district court judges knowing what really goes on. I mean, because the other way that some of these, and I know that this happens in the copyright area, like they're threatening to sue you for infringement,
extortion,
and it's basically extortion. And the first communication they say up at the top, this is a Federal Rules of Evidence 403 communication that's confidential. And whenever I see that, my first communication back to them is just to let you know, everything you say to me is going to become an exhibit, because including the the extortionary demand letter that you just sent me, because we don't infringe. There's no dispute here. And I don't agree to the confidentiality, because confidentiality can't be unilaterally imposed. And it certainly can't be a Federal Rules of Evidence issue before a lawsuit is even filed in a shakedown scenario. What I want to see is people actually stand up and fight and expose what's really going on.
But that's the problem, right? If you're going to get out for 10 grand, you've got to go right to the CEO or whomever and say, well, we're going to fight this. And, those conversations are had, but it's usually after, well, this is the 6th time. We need to make an example out of someone. Mm-hmm. And even when you do that, you're only taking it so far.
So I guess, but Gateway had for a long time, and I think they probably still do, a policy. We just not going to pay. If you want to sue us, we're going to challenge your patent. And that was a very successful way for them not to have trolls going after them.
Well, Research in Motion had the same policy, and it didn't work out so well for them. They paid hundreds of millions of dollars and probably ended up tanking their entire company fighting. And this was before the PTAB, so I'm just showing you the value of the PTAB. But, yeah, you can do that to an extent, but then you don't want your business to become, well, I'm going to be the gladiator against patent trolls, right? There's no budget for that. And so, prudent business people have to figure out what makes sense so that they can continue doing what it is that makes them successful. They don't want to be a full-time, unified patents.
So at the risk of not liking my answer, or your answer, me not liking your answer,
okay.
Where do you see this going? This is where he predicts something horrific.
There's legislation that's proposed. I don't think it's very serious legislation. It's not to say all of the ideas in there are bad, but most of them are, at least with respect to reforming the PTAB, just so far in the direction that's, anti-tech that, it just doesn't really have any chance. And so, then I guess it's left to the agency to try to tweak some things here and there. And I think, to the PTAB's credit, they have done a lot of things to tamp down on serial filers and parallel filers. Going back to the legislation, could the world do without the joinder provision? Probably. It's not going to make that big of a deal. But ultimately, I think we end up in the same space that we do with 101, which is, you've got the two poles, neither one wants to give ground, and so we're just going to stay where we are, and we're just going to get these incremental changes going forward.
Yeah, and I unfortunately think you're probably right. There's a lot of stuff in there I think that makes a lot of sense, and there's stuff in there that's just not gonna happen. But I just don't understand, and I've told everybody that will listen to me, is there are clearly things that could be done to make the PTAB better and make it more neutral. Like, for example, I still don't understand why there is no ethics code that applies to the judges. And they'll say, oh, there is an ethics code. Yes, the ethics code that applies to the judges is the same ethics code that applies to the janitor. The same, all employees of the Department of Commerce. So whatever employee you are at the Department of Commerce, you have, but that is not a judicial or legal. It says, like, after 1 year, conflicts, you don't have to worry about them. Well, for the rest of us, it's a forever issue, as we were just started off our conversation with today.
Well, and I think the issue there is not so much a reluctance to do anything, but you get into, well, it's the government, and who's going to come up with this? Well, let's get justice involved. Let's get the Department of Commerce involved. And, it's just a slow grind to get anything like that done. And my understanding is the board is working on some kinds of ethics reforms, but it's just a slow process when you're talking.
And the thing is it would apply to almost nobody, right? Because I think it's an extraordinary situation when they're acting unethically, but there have been at least one person, maybe a couple of the others were made mistakes, or maybe it was a technical whatever, but there was one person who clearly clearly should have not done what he did. And out of all the judges that the PTAB has always had of all time, we were probably, I'm guessing, but probably around 1,000 former PTAB judges, current judges, and maybe former, maybe not 1,000. But since they moved to the PTAB, it's many hundreds more than are currently there. And, you know, so we're talking about a very small populace that would apply to, but it would create an awful lot of goodwill, I think.
Yeah, you clean up the ethics, you create goodwill, but I think the thing I'd like to see at the PTAB is for the contested cases to have standing, you know, just like a deck judgment. You know, you can't just wake up one day and say, you know, I'm going to take out 5 patents. You can do that with re-exam. Anyone, any day, do it, you know. But you can't and shouldn't have access to the equivalent of a federal courthouse just on a whim. Mm-hmm. And I think that was ill-conceived on the part. I know they were trying to fix inter-party re-exam, but I think it was ill-conceived in terms of standing. I think there has to be the same standing you get in to the PTAB as you do for a deck judgment.
So I fundamentally agree with that, but I would be perfectly okay with keeping it the way that it is if the estoppel provisions actually mattered. If we actually had a realistic view of what it means to be in privy, and we don't.
Well, see, that would solve it, though, because then, you know, those who are going around creating the apprehension of a potential litigation, you know, you're not out there suing Unified Patents.
No.
You know,
no.
Or RPX, you know.
No.
That's not who you're threatening.
Yeah, so it seems to me that there's an awful lot of layups to make the PTAB better, more efficient, and not cause it to lose sight of the mission to get rid of bad patents. Whatever bad patent means, let's just, I always say a bad patent is one that shouldn't have been issued, period.
Right, and I think we can all agree that the system isn't helped by bad patents, you know, that simply don't square up according to the statute. But to be able to have access to such an awful tool on a whim, you know, I think that's unfair.
Yeah.
Well, with the dysfunction in our government, I wouldn't look for any kind of legislation. I mean, we're going to be doing impeachments and, you know, budget wrangling forever, it seems. And, you know, you can call an IP bill the fight against China or a jobs bill, and it's just, right, you're just not going to have the appetite to tackle issues that the vast majority of Americans just don't care about. So I think we have to look at the PTO leadership. There was that substantial rules package proposed, and you know, I expect that to be pared down considerably, but you know, we'll have to see. We'll see.
I mean, any word on when that's likely to drop, the next shoe?
No, I mean, if I had to guess, I would say it's probably sometime after the end of the fiscal year, so probably October.
Oh, really? I was thinking we might get it like right after Labor Day. Because
just,
I mean, if
everybody's so busy this time of year with the that's.
But if she wants to get anything done, she's got to move pretty quickly.
True.
And she being Director Vidal, because you know, we're going to be pretty soon into an election year, and
if it is pared down, then it could be done quicker. But you do have the 15,000 or whatever it was comments, even though a lot of them were kind of, we'll just say.
I know. You know, and let me just say that while we're on this topic, it does not help to have 10,000 people file the same comment. It just doesn't.
No.
I mean,
if you're only interested enough to spend 10 seconds on some template, you're not really communicating any kind of urgency.
No. And what I've also been told by people on the Hill is that picking up a phone and making a phone call, that does matter. Because it takes a lot more energy,
right,
and a lot more ambition to actually dial the digits,
right,
and to spend the 5 minutes you're going to get, or 10 minutes, or however long you're going to get on the phone with some staffer.
Although you can't really do that with the PTO, I guess. But
no, but like, I mean, if you're going to try and affect change, and all you're doing is copying a form letter, you can't come up with your own email, you can't come up with your own story, you can't call your member of Congress or senator or something, just save the 15 seconds it did cost you to cut and paste.
And I've had this conversation online. Ask for things that you can actually get.
Yes.
And I was told that I don't understand the Constitution and I'm just a patent attorney. But, you know, you can't ask an agency to overrule statutes. You're just going to lose credibility, and they're not going to listen to you the next time. And so,
right. Well, a bunch of inventors got mad at me when I wouldn't back their small claims court idea for patents. I'm like, I think it's a great idea. It's just not. It can't happen.
Yeah.
Read the Constitution. Read the Bill of Rights. If more than $20 is at stake, the other side you're suing has got a right to a jury trial.
Well,
and they don't waive it. Why? Because it's better for them.
Not only that, but you don't want that as a patent owner, right? It's the asymmetry in the expense that it's part of your leverage, right? That's what people don't like about
patent
the PTAB.
owner leverage,
right? Well, if you're, competitor to competitor is a little bit different, but if you're out there licensing or you're a non-practicing entity, you want that expense on the other side. You don't want small claims.
Right. Yeah. So, particularly the small. Okay, I get it. So the smaller amount of money that you're looking for, the more asymmetry you want, because, that leads to one of the greater ironies is the more important and valuable is that you've invented, the more likely it's going to be declared invalid, and the more likely that they're going to fight you until the patent is not just expired, but you're in the ground.
Yeah.
You need to invent something that's not particularly valuable, and then ask for $10,000.
And hope Microsoft doesn't infringe it, because they don't infringe valid patents after all.
Yeah, that's what I heard.
No one accused of infringing a patent ever believes the patent's valid on the other side.
Right.
And,
so this is a great conversation. I really appreciate it. The last question that I have is simply to go back to, you've said stay working in the PTAB stuff, but I think I understand you're going to head up Wolf Greenfield's DC office, right? So do you have a sense of how that's going to play out? Are you going to be splitting some time with management responsibilities, or?
I don't know yet. I'll know tomorrow, but the idea certainly is to grow out the capabilities in that office, and looking forward to doing that. Haven't been awarded any titles or anything yet, but I'll be the first partner that's there, resident full time in that office. So I hope to get involved in all that, and looking forward to building out that team.
Great, awesome. John, any other questions for Scott?
Have fun. You're at that time in your career where things should engage you not by obligation but by interest. So have fun.
Yeah, I plan on it.
Good. Great. Thanks a lot, guys. I appreciate it.
Thank you.
Thanks, Gene.